Podcast. So happy to have you join us today. What we essentially love to do is actually share different legal cases involving employment law, specifically harassment cases. And we did find a jewel. So we actually was taken to Arkansas by a random wheel, and it was time to share with a case that's involving a Fortune 500 company that at some point I would think everyone has had some type of experience with at least once in their life, as probably, let's say, a teenager and older. So if you're someone who likes to order things online using, e-commerce, or you need to ship something to someone, then there is a high probability that you have at some time used UPS. So that's who we're talking about today is UPS. So this wonderful company, you know, let's talk about what information was found on UPS. Okay? So essentially, this is regarding Debbie Brown. She was a part time supervisor and she filed a complaint in 2013 against UPS for gender discrimination and retaliation. She wanted to be promoted to a full time supervisor, so that was the ultimate goal. And she worked there for a pretty long time. There were testimonies covering since around 2007. And so this is 2013 when she filed her suit. So based on that time frame of at least the testimonies, we can at least say 6 years, right? Could be longer. Didn't get the information shared in the case as to her hire date, but for sure we know she was there at least since 2007. This actually happened in Texarkana, Arkansas. And what she was alleging is that UPS violated the ACRA law in Arkansas, which says, and it was the first civil rights act in Arkansas covering discrimination based on race, religion, national origin, gender, or the presence of any sensory, physical, or mental disability. And it actually was acted upon in 1993. So I'll let you go ahead and digest that for a little bit, but this is the law that she's using. So basically, she's saying retaliation, harassment, intimidating her, refusing to promote her. But not only did she stop there, she collaborated with another female coworker who basically said, I've experienced the same thing. So she added this other female coworker to the lawsuit. Her name is Louise Pills. And this was also a part time supervisor who wanted to be full time. So just keep in mind, if you're in HR, if you're an employee, or if you're the employer, that there are differences between a part time and a full time employee, especially in terms of benefits, right? And obviously, the more hours you worked, if you are an hourly worker, you're going to get paid more money. So they probably had good reason to want to go full time. Okay. Now, Louise herself actually started working for UPS in June 2005. She started out as a temp and obviously impressed them enough to get hired. So 2005 for her, and once again, this complaint was filed in 2013, so we're talking about 8 years for her. So she basically is claiming that she's denied the same benefits as males. She's denied equal pay based upon the same act. The Arkansas Equal Pay Act is also added. And also, what UPS and what any corporate company or employer is going to do is going to try their best to have an affirmative defense to say they had good reason. They had good reason not to promote either one of these ladies who seemed to be pretty loyal and dedicated based on the case information and based on testimonies. But UPS said, no, we have good reason not to promote them. So listen to us. We have a defense. So they had a lot of their managers testify. They weren't like trying to take down these two workers, Brown and Pills. So they actually allow the management team to testify that both of them were good workers. Say they included that. That was included in the testimony. What they said was that they had other applicants who were better qualified. And how many times have you heard that? Let's just say you apply for jobs with any company and sometimes if you're not selected, not even for an interview, you'll get that little letter that says, we had other applicants that were better qualified. Woohoo! So is that an easy way to out for an employer, or is that just the truth? Which one is it? So they also said there wasn't any record of Brown recently passing a required test called MAP. So it's a management assessment and promotion process. It's an aptitude test, which, as an employer, I want to warn you, you got to be careful if you're using those aptitude tests. Make sure they are validated. Employees have sued because they weren't hired or promoted based on aptitude tests, and guess what? Some of those employees actually won. So be super careful, make sure it's totally validated and it definitely justifies using it. But this wasn't the issue in this case. They didn't even plead that. They just said that they didn't have record of Brown taking the MAP recently. This was the argument for Brown. They just didn't have that, and that's a requirement to get promoted to a supervisor. So they're basically saying, well, she fell short. She didn't have what's required to be promoted. Okay? And they said this other applicant who did get promoted not only had the test, but also had driving experience. Even though that person who was promoted did not have supervisory experience, they did have driving experience. Any way they want to twist it, they can do it. I'm telling you. So the burden of proof, let's talk about this. So who is the burden of proof on? Well, it really depends on which law is argued. So initially, UPS had the burden of proof. And well, let me rephrase. According to Brown, the plaintiff, UPS should have had the burden of proof based on a law she was arguing. However, the court did not see it that way. The court said the burden of proof always remained with Brown. So the burden of proof was with Brown. So if Brown, so she has a prima facie case that she has to prove. If she can prove that, that's her burden of proof. If she can do that, then it shifts over to UPS, their burden of proof. However, based on the court's decision, Brown never met the burden of proof. So she didn't have a prima facie case. So therefore, it always stayed with her. And that's why UPS won. She didn't have enough proof to say that the reason why she wasn't promoted was because of discrimination. And she said gender. And I will tell you, it's very hard to prove that. Okay? Let me show you something with EEOC. Okay? And I'm sorry, the screen is like so minimum, but these are cases since 2009. This is the EEOC. Okay? And so let's look at 2013 is when they filed. At that time, there was 24 cases. And this is for Arkansas, just to let you know. Just kind of go up a little bit so you can see the proof. So this is for Arkansas, and it's covering all these years, but the year that we're looking at is 2013. And there's 1,524 cases filed. This is total discrimination cases for the EOC. And then the EOC, in terms of, the sex or gender, was 487 at that time. Out of the US, that was 1.8%, but for Arkansas, it was 32% of the discrimination cases filed. With that being said, um, it's just tough. It's tough to prove discrimination unless someone is walking around saying, I'm not going to promote you because you're a woman, or I'm not going to promote you and make some type of comment that only is targeting women. It's hard to prove it. Just because you are a woman and you're not promoted and all these males are promoted, you would think you would have a chance, but it's really hard, especially when you're going up against an employer like UPS who has tons of money and can spend tons of money finding the right attorney who can twist and spin everything around. And I'm just being honest about that. Um, so Brown did file a EOC claim, but obviously it didn't go anywhere because she was filing this lawsuit to still try and get a resolution for the discrimination that she felt she experienced. But the moral to the story, just to let you know, is that unless, and I've reviewed tons of cases, and you can look at EOC stats, the number of cases that come in and the number of cases they actually take to the full uh, review process, and they actually end up charging the employer is a small percentage. So, what I would say to you as an employee is possibly decide for yourself. And I don't want anyone to be discriminated against, but the time that is spent trying to prove it, especially if you're spending money, you might want to rethink it by looking at these stats and then looking at how many cases EOC really takes to court or actually sues the employer, and then look at legal cases in your state to see how many people are really winning and how are they winning. You might want to consider maybe another employer if you're not, and I don't want to like allow employers to get away with things like this, but I just want to tell you that it is so far it's been really hard to prove. I have read so many cases and it's rare that they're won because an employer can twist things and say, like in this situation, even though the person they promoted didn't have supervisory experience, you would think that these two ladies who both had supervisory experience, they were dedicated, they were like working off the clock, even though management asked them not to do that. And that's the right thing. Managers, you do want to ask your employees not to work off the clock and document it. But even though they continued to work hard and was dedicated because they one day wanted a chance to be that full-time supervisor based on their loyalty and hard work, it never happened. I mean, as far as this case is concerned, in the 2013 case, I don't know what happened after that. But so if you feel like you're just hitting a brick wall, you have to really evaluate your standing and how much you want to fight for it, or if you feel like you need to move on. And I don't want to just say that because I know I'm going to get bad flack for saying this, but I'm just a straight shooter and I've read tons of cases. You spend tons of money with legal fees and you end up not winning. It doesn't mean that you can't win if you have the type of case where someone is calling you uh, degrading names because you're a female. They're saying you're not going to ever do anything because you're a female or your race or whatever. If you have that type of case, for sure. Without that, you have to make sure that is strong enough to really withstand court systems and EOC processes. So I hope that this helps someone who may be contemplating that. and do your own research for sure. Don't take my word for it. I know I'm going to get some flack for this. I know I am. But I'm just trying to help save a lot of money and heartache. Because, first of all, I know it's tough going through it. And then, secondly, if you're putting money to get attorneys and stuff to help you just to get to this point, it's hard. Okay. So just think about it. Okay. All right. I wish you the best. I'll be happy to hear any comments and feedback. That's what it's about, right? Freedom of speech. So share with me. Tell me what's going on, what's on your mind, and have a great day. And please subscribe and just learn, give us feedback on what you like to see and hear. Thank you.